apply the patent? What are the step-by-step process as procedure to approach the patent? After the getting the patent, what is the benefits and how we make it a patent as a money? These kind of things I want to discuss another 1 hour, exactly 15 minutes. So my sincere thanks to the principal of this institute, head of the department, Dr. Santosh, Dean Directors, and my dear friends and the participants. So the introduction, what is a patent? A patent is the right granted to the owner of invention. What is invention? It's something new, or it's maybe new process or methods to improve the existing system. That is called as invention. That invention prevents others from making, using, importing or selling the invention without his permission. Suppose I have some property in my native or in city or whatever it may be. Without your permission, they may not enter in your property. For example, any building or any land, even bike or car also. So you are the owner for that. Similarly, you have some idea, some lateral idea or lateral thinking. That is your asset. That asset, how will you make it some money or the rights? That's a patent. Right? Suppose this patent, that's your idea, give some legal aspects. Right? Your ideas may be registered in the register office, like that. Suppose you have any property or you're going to buy the property or sell the property, you register document in the register office, right, with the judicial stamp paper and all. We'll make it as government document. Similarly, your idea also, it may be documented, make it as a wealth. The provision is available in our Indian law also, the Patent Act 1970. Just you can type in the Google, you can get it. Patent Act 1970. It gives all the provision as Indian or non-residential Indian or other country. Non-citizen also can apply the patent. That kind of provisions are available, and all over the India, the same process may be followed. A patentable invention can be product or process. It may be product or process that gives a new technical solution to the problem. New technical solution to the problem. So it can also new method of doing things, the composition of new product or technical improvement on how certain jobs or works like that. So that is called as invention. So you have some idea, right? You have some idea. So how you check whether your idea is new idea or old idea or idea for improvements in systems? We have some search engine. Using that, we can search either our patent is may be patentable or may not be patentable. Then you may have some question. The patent is a lifetime rights. My answer is no, is not a lifetime rights to hold some technology in your hand itself. It is only 20 years of the rights, date of filing the document. This is very important. Date of the filing of the document. Getting the patent is something different. Date of filing the document. Subjected to the payment of annual renewal fee. Every year you want to pay the money and renew the patent because you are holding idea. No? So that idea anyone can use with your permission. That rights given to you up to 20 years only. So after that, that is the wealth of our nation. Now, benefits of registering patent. What is the benefit? Once you register patent, apart from using the patent to prevent the others from exploring your invention, you can employ it to raise funds of your business. Suppose you have the rights or the patent rights or patent. You can employ to raise the funds of your own business. You can sell the patent, and you can give the any mortgage or license, or you can sell also possible your rights. So that is the benefits of registering the patent. Now the key criteria for the patenting and invention. Suppose I like to patent some new ideas. New ideas. So my ideas for some technology, some ideas for maybe some geographical location, some idea, my ideas some related to some new design. For example, for example, this figure also, right? The bulb, I want to change the shape of the bulb. You have the rights to register design. That is the thing. Now, the key criteria for the patenting and invention, it should be new. It should be inventive step. It should be industrial applications. These are the important things. You may be register the patent. It should be new, inventive step. So you may be give first step and the last step. In between you not given, no, it's not accepted. Right? For the industrial application, that is a must. So these are the key criteria for patenting and invention. Now, how do you find your innovative ideas is patented or not? Suppose I have ideas, sir. I want to replace the cement by some material. So I have some idea. Otherwise, I want to find, or otherwise I want to show the electrons movement in the conduct or wire. That is my idea. So somebody is thinking, I want to find the supercomputer or super ultra super fine some computer like that. So some hardware I want to find. So before that, like Google, like that. Suppose you want to go that Mangalore to Udupi or Karwar, something. First, I am new person. As I'll encourage some people. Otherwise, I just type in the Google map. I can get when suppose I start from Mangalore to Udupi. How much time is required by train, by car, by walk, by other mode of transport, flight also, right? So these kind of things is given by Google engine, right? Google engine. So similarly, you have the patent. First, you have some idea. The search engine is available. That is called as a general search engine. It is google.com, like that. Patents.google.com. https:// patents.google.com. This is gives the some idea regarding the patent, right? For example, how to search the patent? I have some idea. I can just type my idea in that Google. You can get. Suppose similar idea, similar key points or similar keywords is present in that search. So you may be change the idea, or you may be come to the conclusion this kind of ideas already available in the world. That's the thing. So these are the some search engines. For example, there is a www.freepatentsonline.com, www.epo searching for the patent HTML, United States Trademark Patent Office UT USTPO ITSPO, www.uspto.gov, World Intellectual Property Organization WIPO also is there. So these are the some websites you can see. For example, I want to show some websites here. Website is opening. Wait just a minute. Yeah. Dear friends, you can see my screen now?
Yes, sir.
Friends, you can see my screen? Yes, Google pattern screens, correct? Yeah. Just this is the Google patent screen. Just suppose you want to like concrete battery. Concrete battery. Right? You can see these are the patent search engine. This is Google patents. I have around these two keyword. I have around 1,35,828 result. Right? Though in case of the concrete battery itself. So again, you go for some keywords, you can get more idea. Then bipolar battery assembly, like that. These are the patent documents you can see here. So this is the patent document. You can see how they made the battery cover and cell and everything. The complete figure and working principle, all the things is given. One just you can see this is the patent number US 16106393814B2. This is the patent number. So you can see this patent. This is the description and all those things I want to take hands-on training, how to write the specification and everything. Right? Similarly, you go for the different pattern also. You can see my full screen mode now. Presentation. Yes. Similarly, I can search with respect to the keyword. If there's no citation is given in that website, I come to the conclusion my pattern is or not, or it's maybe available or not. Some person is maybe asked, sir, I have the very good idea in masters and BTech and PhD level also. I already published the paper in the reputed journal, High Impact Factor Journal. Can I register the patent? My answer is no. It's nowhere, anywhere is published your matter, either in small newspaper also, it may not be claimed as a patent. Okay? It's impossible. So, before start the work, you should register the patent, then you start the work. That is the best advices from our side. As a Patent Act 1970, Section 2, 1J, the invention means the new product or process involving a innovative step and capable of industrial applications. That is called as invention in 1970. So this is the Patent Act 1970. You can see in the chapter 1, 2, 3 different section. It's available. Section 1, Section 2, Section 3. Under the Section 3 is given invention not patentable. Not patentable. For example, in case of the matter related to atomic research related things may not be patent. Santosh also discussed with me. He unable to get the patent because his research related to atomic related things. Because the section in the Act 1970 Section 3 Chapter 2 we cannot go further. Some matters may not be patentable. And what are the not inventions? The following is not inventions within the meeting this act as per Act 1970 Section 3. It is an invention which is playful or which claims anything obviously contradictory as well as established natural laws. Suppose you can claim the sun is rising daily morning from west or south or north. Not. So these are the things. It may not be patentable. Then, like this, we have a number of matters may not be patentable. I want to summarize it. What is the section and all? Different section we have. For example, section 3A, section 3B, section C, D, E, F, G, H, I, J, K, section 3, K, L, M, N, O, P, like this. Right? So these are the matter, these may not be patentable. Suppose you file the patent office, the controller of patent, reject your patents. Right? Then section 4, invention relating to the atomic energy is not patentable. There is a special Act 1962, 33 of 1962. In section 4, may not be patent any atomic related matters. So the patentable is a subject matter. The invention must relate to the process or product both. It's new, involves in inventive step, capable of industrial application, not fall under the section 3 and 4 as per our Act, ACT Act 1970. Invention must not be published in India or elsewhere. Sir, you have some questions. Sir, I am the computer science students. I am EC students. I have the very good algorithm and the program coding. May I patentable? My answer is no. So any written matter, you can patent, you cannot be patent. You go for the copyrights. Similar weightages we have the copyright also. That coding and all, you can copyright. Suppose some electrical students ask, sir, I have some circuits for the solving some solutions. So you may not be claimed as a patent, you can claim as a copyrights, circuits and all those things. Suppose you design the circuit board, you invent some circuit board, that's maybe patentable. That is under the category of hardware and all those things. In mathematics people also, somebody asks, sir, I have the very good mathematical steps like a Ramanujam and all. So I can go for the patent. My answer is no. So you go for copyright only. Sir, I am an artist. I have the very good knowledges for the drawing and design the new emblem or design the new shape of different drawing and all. This again go for the design, patent design, and you go for the copyright documents. Suppose you have some very good knowledges in the playing of keyboards, or you have some script of musical track and all, like our like musician like A.R. Rahman, Ilayaraja, and other music directors like, they cannot be claimed it's a patent, they have the copyrights. So that is the limitations of patents. Then prior public knowledge or prior public use within the India may not be. So it should be, be careful. The prior public knowledge or prior public use in India, it should be new. Claimed before any specification in India. This is the matter, should be new. Then, what are not invention as per Act 1978? Quick review, right? For example, some people, some mechanical people, they claiming, sir, I have the machine with 100% or more than 100% efficiency. Very, very difficult. We cannot achieve the machine more than 100% efficiency, right? Like that. Or some person as a claiming, sir, I will find some machines for gambling, and I find some bomb, like kind of things. This may not be patentable. So you have some idea means you may be errors in your mind. Then suppose that section 3 in the Act 1970, Newton's law, superconducting phenomenon such as property of certain materials to withstand the mechanical shock. These are the natural law. No? For example, F equal to ma, you cannot claim as a pattern. This is law, Newton's law already we found. So these are the things matter, it's not. But even this formula, it's not accepted for the pattern. But technology, it's maybe patented, possible. Then some crystals is forms or substance, it's formed naturally occurring minerals and all those things, you cannot be claimed is the patentable matter. Then for example, the substance obtained by the mere admixture resulting only in this aggregation of the properties of the compounds, thereof the process for the processing such substance, it may not be patentable. For example, I can you have some machine already. You can add some attachments in that machine. For example, cell phone. You can add the cover. That may not be patentable, right? The cell phone without antenna, that may not be patentable. The cell phone is a device that may be patentable, right? Cell phone like that. For example, our bucket fitted with a torch, the umbrella fitted with a fan, the clock and radio in the single cabinet, floor mill provided with a ceiling. These are the not patternable. Already the system is exist. That is the extra items you add in that previous one may not be accepted as a new invention or pattern. For example, method of agriculture or horticulture. Method of agriculture and horticulture. How I can plant that rice, paddy, or some sugar cane. That are the things not patternable. But the method of farming, method of creating the seeds, and method of irrigating, that are all the things we can patternable. For example, cultivation of algae, producing new form of this known plant, right? Suppose I want to plant some paddy, that is not a patternable one. Suppose you find some new varieties of plant, that may be patternable. And agricultural equipments are patternable by tractors, some other equipments, seeders, like kind of things, we can patternable. Then any process of medical, surgical, and pro-plastics and diagnostic process may not be patternable. For example, a removal of cancer tumor, that is the process, not a technology, not a pattern. The removal of tendon and plug and carries, the surgical process, we cannot be patterned. The process relating to the therapy, all this pattern. Method of vaccination, blood transfusion, it's not patternable. But however, the treatment performed on the tissues or fluids permanently removed from the body, these kind of things we can be patternable. That is the possible. These are the things is the possible. Then plants and animal in whole or any part thereof, then microorganisms, but including seeds, varieties and species, and especially biological process for the propagation of the plants and animals, it's not possible. But the clones and new varieties of the plants possible. The process of production of the plant animals, if the consist of entirely of the natural phenomenon such crossing the selection, essentially biological process, it's a possible. The mathematical or business method or computer program or algorithms, the computer program by itself and record of the area, this not may not be patternable, but you can get that copyright. It is a possible. Copyright is possible. Then like a drama, musical, artistic work and all those things, it cannot be patternable. The some games also not patternable. Then the presentation of information, suppose I have the very good PPT or visualization and all those things, I cannot claim as the pattern, right? The presentation of information, example, any matter or method of expressing information, whether by the spoken words, visual display, symbols, diagrams, may not. The information recorded on the carrier also may not be patternable. Topography of integrated circuit, for example, circuits or some grid, power grids, and circuits and all those things may not be patternable. You go for the design. How it works and functioning, that possible, the process pattern. Process pattern. And the traditional knowledge already known in the public domain, it's not allowed. It's not allowed. Then, in addition that, the not patternable in the Section Act of Section 4, 1962, atomic related matter, it may not be patternable. So, now we can come to the conclusion, which one is the patternable, which one is the not patternable, right? For example, I can quick review. So, suppose I have the circuit, may not be patternable. I have some algorithm, I cannot be patternable. I have some mathematical calculation and step, cannot be patternable. I have some methods, I have some land, I want to cultivate some plants, that may not be patternable. So I have some idea, suppose I have the brick, fly ash brick. Instead of fly ash, I will add some other material. So that may not be get that any patent process, but that is the alternate process. You cannot be get the patent. Then types of patent. One is a utility patent, another is a plant patent, another one is a design patent. Right. So we want to take mostly go for this utility patent. Biology and all, we are using this plant patent. Design patent for that some textile and some car manufacturers, bike manufacturers, and automobile industries go for the design pattern as well as utility pattern. Right? In case of the plant patent, you find some new plants, you go for this. So I want to talk more about this utility patent 90%. The grant of patent. Who can file the patent application? And where to file the patent application, how to file the patent application. So I want to take 2 minutes here. The who can file the patent, right? Who can file the patent? In India, section 6 and 134, 134. The applications can be filled either alone or jointly. Up to 30 members allowed for the single patent, right? Application can be filed either alone or jointly by any person claiming to be true and first inventors, by any person being assigned or person claiming true and first inventors, by legal representatives of any desired person, he can claim as applicant. For example, my patent, NATK is the applicant. I am the inventor. My scholars, UG and PG scholars, as the inventors who are involved in this one. Similarly, you may not be applicant. You assign some legal advisors or lawyers. They will take care of for your patent. Behalf of you, they will file all those things. You have the mind, that intellectual, you can make its rights using the legal advisors and all. Where to file the patent applications? You have a lot of doubt. So you have idea. Already I searched in the net, Google patent and US patent and all those things. So I have idea where I want to go. No need to go anywhere. Just to open the following websites, you can get idea. Or you may be in person also, you can go. In case of India, we have 1, 2, 3, 4 regional patent office at Chennai, Mumbai, Delhi, New Delhi and Kolkata. So these are the states is coming under the Chennai patent office. I register patent around 12 patent in the Chennai office, 2 patent at Chennai office, but branch office at Bangalore, Chennai, 14, yeah, 1 plus 2, 14 patent here only, the Chennai office only, because we are coming to the Karnataka and as well as the Tamil Nadu are using this patent. So otherwise, how to file the patent, right? Your documents can be filed in the patent office through online e-filing is a possible. Otherwise, you download all the document form 1, form 2, form 3 up to 32 forms available. Whichever form is applicable, you download the form and fill it and submit with a fee in the office, directly in the patent office in the Chennai, Mumbai, New Delhi and Kolkata with respect to your geographic location of your place. Or otherwise, you goes to that this website. I hope you can see my website. You can see website now. Anybody, please?
Yes, sir.
Yes, thank you. So this is the website of the official website, Office of Controller of General of Patents, Design and Trademarks. I already told you, I am talking about the patents. We have the designs and the trademarks. Design and trademarks. This also trademark, IP, Intellectual Property India. You can see this logo under the trademark. Suppose our Honorable Prime Minister wearing the dress, the netting pattern and all comes to the design, right? This is things. So here you can have the patents, the about us, administration, designs, and trademarks. This is the major things. Then e-filing also available. You can file this things by e-filing option is there. this is increased register. Where is the e-filing operation? Yeah, e-filing option available. Yes. So available, you can file in that patent office. We have the different forms also. Yes. So this is, we have that this kind of search engines. You can see it is advanced search combs we have. What is that? E-filing process. What are the document is need, and all those things available in that website. You can get it information. I will show that documents, not an issue. Then through this we can go through it and download the forms. You can submit it by online or hand also. The general procedure for obtaining the patent, one is the filing the application, filing the patent application, publication after 18 months, pre-grant opposition, request for examination, examination, grant of refusal, publication of grant of patent, post-grant opposition, and decision by the controller. I will take 3 minutes here, right? Filing the patent applications, that standard formats available in that patent website, IPR website. You can download it. Different formats available. You can decide either who are the applicant, who are the inventor. Applicant, you may be applicant, or your boss, or any institute, or any sponsor authority, it may be applicant. So inventor, up to 30 member you can add. It should be Indian. Suppose you go for claiming Indian patent, it should be Indian. NRA also allowed. Then after that, you have some idea. We have the two option. One is the provisional. Another one is the complete. This provisional, suppose you have some idea. That idea, you can register this idea within some paragraph, abstract of your invention. You can register these things in the patent office or in the e-filing patent system. So nobody claim this is others idea. Up to 1 year, this title, that innovative idea, it's a holding for you. That is called as a provisional. Within 1 year, you develop the provisional idea. You give the detailed specification and a detailed claim. What is a detailed specification and claim means? Claim means you give this more explanatory methods how to do this process in that field. That is called as complete specification. One is the provisional, another one is the complete. After the complete specification, your matter, you should be note down, your matter publish in our IPR website up to 18 months. After the 18 months, so the IPR office got a lot of queries regarding your patent. Suppose your patent published in the complete specification in IPR websites, all over the world, the people looking your patent. So most of them grant the patent against you, because this is IPR related matter, no? So I am the very good IPR, I am the intelligent. Who will allow? No one allow. It's right. Always pulling back to the pavilion. For that, immediately you get a lot of commands regarding that patent. So after that, you ask that request for the examination. Without requesting examination, the patent process may not be started, right? So you request the examination. What are the command received from the public domain, and with respect to that, you request the examination. Then you pay the money, this document sent for some patent of controller of patent. Okay, they will look at your patent and innovative ideas along with the command raised by the public. You can get the first examiner report, right? So the no queries is come down from the public, no queries raised by this controller of patent. So directly go for the patent approval or patent grant the patent. Or they have some raised the question and you want to argue with controller of patents by yourself, or you may be apply some lawyers, that is a pattern of attorney general, then they will argue with their controller of patents like a court, then they will get the patent, right? After that, our explanation is satisfactory with the controller of examination for the patent. After that, the patent may be published or granted. For that, before and after examination, you can oppose the patent. That is the post-grant opposition patent, pre-grant opposition patent. So you can argue this is not worth, this is not suitable, like this, like a stock market, like that. After that, the controller is maybe give the patent. So each and every stage you want to pay the money. For example, provisional registration, you want to pay the money. After the confirmation, the complete specification, pay the money. Request for the examination, pay the money. After that, no need. After the getting the patent, every year we want to renewal the patent. So this is the process of patent from 2005, right side, pre-2005, this is. Pre-grant opposition at present available. Before examination, pre-grant opposition available, before it's not available. Right. This is the forms and fee. Suppose you can open the net, you can get all the forms, right? The first is fee, schedule of fees, application of grant of patent. First, this form should be filled, right? First form, application of grant of patent. Another one is the provisional and complete specification, the same form you can use for the provisional and the complete. Already I told you know what is meant by provisional, what is meant by the complete specification. Then statement and undertaking under the section 8, I am the Indian and like things. Request for extension of the time. Suppose you may not be aware about that renewal of time, or you may not be aware about that when I want to complete the pattern, renewal the pattern, all those things, you have some time. And the declaration of the inventionship. So declaration is given in the form 5. The claimer request regarding these changes the applicant for the patent. Notice of opposition. I already explained now what is meant by opposition. Then likewise, we have that n number of forms. I will show that one form. It's very easy only. You can see the form 1. Yeah. Again, this is IPR office website. You can see the first fees schedule fees. What is the fees and all given. Application for the grant of patent. Right. This open this. You can get this form. Very simple only. Mostly I am up to 14 patent. I am not entertain any lawyers for my patent. Myself, my research scholar itself, I did all those things. Right? This is a form. It's very simple only, right? Applicant reference, type of applicant, then applicant's name full, nationality, currently in the residence of India, Europe, or whatever it may be. This, then applicant address, category of applications, then inventor, please tick yes, you and others. This is the title of invention here. The manufacturing process of fly ash brick coated with the epoxy. For example, modified integrated circuit for that integrated mobile communication, like that. Then authorized registered patent agents. For example, I am not aware about that patent. You give the power of attorney, right? Some patent agents is there, you can give. Address for the service of the patent in India. Then 8 and 9. This is simple. You can put that side. The form 1 is over. Then similarly, form 2, the provisional complete specification. I want to take 2 minutes here. You can map your time here. Form 2, the Patent Act 1970, 39 of 1970, the Patent Rules 2003, the provisional and complete specifications. Right? Title of invention, applicant, name and agency. Right? Preamble to description, provisional or complete. You can mention it is the provisional or it's maybe complete. You have whole idea, you directly go for the complete, no need for the provisional. Then description shall be start from the next page. The claims, you can look at this, friends, here. The claim, it's a very important. So the description and the claim, it's a very important for the patent. Suppose I want to claim, I have the patent of one material, how to obtain the basaltcrete. So how to obtain the basalt rock, under what temperature I can get the basalt fiber, how I can mix this basalt fiber into the concrete, how it's react, how the strength is increases, like that. So you can claim, for example, I can claim the fire resistance of my basaltcrete, it's a ranges from 700 degrees centigrade to 1200 degrees centigrade. This is one claim, right? So similarly, I can claim if I go for the basaltcrete concrete, my concrete strength, it varies from 50 to 70 Newton per mm square. This is the main claim. Even though we add some mineral admixtures like a fly ash, liquefium, GGBS and all, I can get even more compressive strength, around 10 to 15% increases with respect to the conventional. This is the subclaim. This is the subclaim. Similarly, you can go for up to 10 claims and with the subclaims. Again, you increase more than 10 claims, you want to pay the money. That is important. Then description, how it works, how it does your new invention is better than others. So you have the pattern, more number of claims, your pattern is more weightages. Less number of claim, it's a less weightages of this. Then abstract of invention. Suppose you have some idea, it's a new idea, it's getting in your laboratory experiment, or whenever you're thinking like that, you give that abstract of invention. This is a very simple form, right? You pay the 1,200 rupees and that you can register, you hold your invention. It is very simple step. Don't feel it's maybe big process and all those things, right? Similarly, we have a number of forms like this, right? Similarly, we have the form of provisional statement of undertaking, the declaration of invention. This is important. Form 5 is important. This is a declaration for the invention. This is important, right? Then similarly, we go for that request for publication. This is important. You can see it's very simple process only, but we are not spend time to spend time. Wait just a minute, I'll go for my PPT again. Can see my PPT? Dear friends, you can see my PPT? Full screen mode? Yes, sir. Yes, thank you. Yeah, like that, we can go for that different forms available here. We can go it. Different forms, you can see. Then document required for filing the patent applications. What are the documents required? Sir, I am the BTech students or MTech students, even PhDs. So what are the documents is required? First one is covering letter you can prepare. After that, application of grant of patent, form 1. Then complete or provisional. Suppose I'll give the provisional registration. I need the form 2. Statement of undertaking form 3. Suppose this is the 3 form is essential for the provisional registration. Then I have some power of attorney, form 16 you want to give. Then declaration of inventorship, this 5. The form 1, form 2, form 3, form 5, it's important, right? The certified true copy of the priority document in case of priority is claimed. The request of security fee, DDR check or e-transfer also at present available. This is the typical form 2 for the specifications, right? Title of invention already shown, description, abstract and all those things. What is the main content is needed for that specification? Suppose I want to write the specification, these are all the things you should be need. Title of invention, field of invention, background of invention, object of the object of invention, summary of invention, brief description of drawings if any, detailed description of the invention, examples. These are the need for that complete specification. In case of provisional specification, no need of all detailed document, right? This is a provisional specification. It should be desirable and the nature of invention, contain the description of essential features of the invention. The claims and abstracts are not part of the provisional specification. Fee is to be same, the complete specification. The complete specification must be filled within 12 months from the date of filing of the provisional applications. Already I told. This is the complete specification. We have, these are all the documents. Then what is the fee? Fee for filing the patent application, 1,000 rupees for Indian. For each seat of the specification, addition to 30, 100 rupees. Each claim, addition to 10, 200 rupees. So this is the fee, nominal fee only. Usually I will pay 1,400 rupees. Again, file the patent, right? Suppose I go for that similar filing. These are the things no need, I think. Then publication is important. The request for early publication, it is a possible. Suppose I have the very important patent. So this patent is holding others. The losses may be big. For that, you can join with some company, get the agreement with that company. You can file that cases against the patent office. You can get that early publication within month. It is a possible. You get that publication. You want to pay the money for that. Then imposition of publications, the pre-grant opposition already explained. The request for the examination, no request, no grant. This is very, very important, friends. Don't forget, request for the examination. Once you publish the patent in that IPR website, it's not patent granted. After the examination, we can face the examination report. After that only, we can get the patent, right? That is the first examination report, FER. Is once you get that report, we feel also fair. It may be get or may not be get and all those things. Then the grant of patents. The controller will get the grant of applications upon overcome all objections raised by this FIR first examiner's report. On the grant of patent, application will be accorded a number called a serial number. The series of numbers accorded the patent under the Indian Patents Design Acts 1911 of 1911. So they will give some pattern number 1757 CE, CHE 2014, something like that. Then renewal fee, you want to fee up to 6 years, 2000 per year. After 7 to 10 years, 6,000 per year. 11 to 15 years, 12,000 per year. 16 to 20 years, 20,000 per year. 20,000 per year. My two patents is around 12 years old. So I am every year 20,000 I paying for that, holding the patent, right? These are the patent. So you can see this is my patent. What is the patent? I got the patent recently, this patent, 15/3/2021, 1 year back, right? So myself, Dr. Palaniswamy and Dr. Dinesh Kumar, inventor, data patent 19 29/11/2012. We can think about 2012, 10 years. 10 years later, I can get the patent. Right? So, your patent is validity 20 year from data filing, data patent. Okay, data filing. Then this is the priority date. From this date, I can get the patent. What is my pattern is basaltocrete building blocks. Right? What we did means how we can get that basalt fiber from the basalt rock, how we can take and how make it the fiber. If using that fiber in that concrete, what will happen? What type of property it may be gained? What are the process you can get? More desirable property. These are the things we put in the claim. We can get that 4 claim only. Initially we submitted more than 10 claims with subclaims. Most of the claims they rejected. Finally, we got that pattern with 4 claims. I can claim these 4 only. What the claim means? How I can obtain that basalt rock, how I can peel the fiber from the basalt rock, how I can mix this basalt fiber in the concrete, how does the strength is increases or decreases and all. In addition that, we put that more than 10 claims, but these claims is maybe not patternable given by patent office. So they may not be rejected simply. They reject with respect to some clauses. Already told section 3, A to J, different section we have now. They will give the command with respect to this section, with respect to this article, with respect to subsection, it may not be patternable like that. Right? So we can have that 4 claims. So this is the pattern known. The intellectual property, India, they'll give the pattern. This is my pattern number. 4959 CHE 2012. This is the pattern. This is all over India. The same sequence they are following. Right? And we went for some attorney also, power of attorney for the first examiner report. We also faced lot of struggling to answer their question. Initially, they the patent office people refuse our patent. They put some article name or some section. This may not be patternable. This may not be patternable. This claim is not under mere these rules and something they put. Again, we want to argue them. We want to oppose the patent, right? So this is my point of view. This is correct. My point of this section, it's a correct. Under the section of this section like that, section like that, we want to against so want to argue with the patent office. Then only they will give 1 or 2 claims. This is the patent certificate given by IPR India, Intellectual Property India. My patent number is 3612222. The application number 4959 CHE 2012. Just you type this is 3612222 in that IPR website, or you can scan this. You can get my patent. This is my I am the inventor for this. Myself and Dr. Dinesh. That's why I put acknowledgement, Dr. Dinesh. Thank you, Dr. Dinesh. Then it is hereby the certificate that the patent has been granted to the patentee for this invention entitled basaltocrete building blocks as disclosed the above the mentioned application. The term of 20 years from 29th day of November 2012, accordance with the provisions Patent Act 1970. This is the patent. So hereafter, I can sell the patent to any agency with legal loss. Right? I can give these rights to others also. I can sell. I can give the lease. I can give. I put in the mortgage also. It's a possible. Then this is another patent I got recently. We got recently. Sorry. 18/12/2020, 2 years back exactly. Thanks to Dr. N. Sudarshan, he is one of my research scholar. Glass-grid building block. Glass-grid building block. Most of the people may be asked, sir, glass is not a binding material. How you can get the pattern? It's a glass-grid building block. Most of my pattern, it's the word carrying of crete, right? Like a basalt crete, and glass crete, microbial crete, clay crete, then paper crete, aloe vera crete. These are some my typical pattern. We are using the word of crete. Now we are developing some equipments for encapsulating of the bacteria for the bioconcrete laboratory. That also is submitted for the patent office for getting the patent. So we can get the 2 claims only for this patent. How to process of glass crete building block. We take that glass powder and add in that LCM, that is a cement and a pozzolanic material. We create some cement using that glass. Glass has some pozzolan, rich alumina and silica also. How we can activate the silica and alumina? By means of some chemical method as well as some mechanical method. We want to etch that the surfaces of the glass particle, then create the bonding between the glass particles and with the cement or binding agents. After that, then mixing together, we can get the block. That is called as a glass grid block. A lot of struggle, we got the pattern recently. This is the pattern I can show prestigely. This is my pattern along with my student Dr. Sudarshan. I think he may be joined this presentation. I got that acknowledgement from him. He asked that is a link he want to join. Sudarshan available now? Dr. Sudarshan? Okay. Fine. Thank you, Dr. Sudarshan. This is the pattern. So I want to conclude my talk exactly. Conclude my talk within 1 hour. What are the things is needed for that pattern? First, you have some idea, new idea, innovative idea. You have some stupid ideas also, not an issue, right? So just go for that patent of patent search, Google patent something. You can type your keywords, you can get it's maybe patentable or may not be patentable, and you can search or you alternate the keyword and all. So before going to the filing the patent, we ask some patent agents. They will offer a lot of option. They will get the money from you. I'm not telling much about that patent agent and all. So you go for a prior art of search. Prior art of search before going to that patenting the process. So you can search your ideas in the patent link. So you can confine and refine it. Then you go for the provisional or complete specifications with the fee. Then file the patent. Then you maybe have some idea which are the matters is may be patentable, may not be patentable, and what is the maximum number of applicant or maximum number of inventor may be included in your patent and all. Nowadays, a lot of patent agency approaching to you, or you give the 1,500 rupees, I can give the patent like that because they are collected 30 into 1,500 rupees. You think about the money, right? Simple patenting process and all. Then examination and all, the complete specification ask again 7,500 rupees as a government fee for the complete specification. 30 into 7,500. Think about the cost of people getting money from our pocket. That is a thing. Then the process is simple. Once you have the very good idea, you can go ahead. So my best wishes to all my B.Tech and M.Tech and budding researchers, even senior professors and others also. You have some idea, don't keep it in your pocket, don't keep it in your classroom itself. If stupid idea also, it's a possible, pattern it. So my best wishes to this institute, coming up more number of patent. I ignite some small spark about that pattern. This is ocean. You can go explain, sir, go in the deep. You can get more idea. So with after this time, one pattern is coming up from institution. It's very happy for this presentation. So thank you very much, the patiently. You learn my lectures today. So this is the discussion session. You have any queries and any discussion, we can discuss now. Now over to organization. Thank you.
Thank you, sir. Thank you for the wonderful talk, and the talk was very informative with respect to the intellectual property rights and patent filing.
Thank you.
Please, if I would like to request the students and faculty members, if they have their questions, please ask to our resource person. Are there any questions? Please ask.
You can ask in person or always you put in chat box also is fine.
Okay, if
comfortable,
some
you do
people are
it.
hesitant to ask the question, you can put it in the chat box also.
Yes, yes. I'm expecting more questions from BTech and MTech students. You have the young mind. Any questions from audience?
Yes, sir. One of our colleague will talk, ask the question, sir. Yeah, yes, sir. Hello, sir. This is Dr. Santosh.
Yeah, you
Can you
can.
hear me, sir? Sir, can
Yeah,
you hear
yeah,
me,
yeah.
sir? Okay,
Yes,
sir.
yes, I can hear.
Sir, thank you for very much for the very informative and wonderful lecture. Sir, I have some queries. I just wanted to ask you some throw some light on some of the things. Sir, you told about section 3E. Uh, can you just throw some light on this section 3, sir, where uh, is it something like I'm making a concrete and I am added a new mixture and this cannot be printed, something like that, sir? Or can you put some light on it, sir?
Yeah, suppose you can. Suppose you have the mix for that making the brick
Yes,
or
sir.
making the tile,
Yes, sir.
making the concrete.
Yes, sir.
That we have the mix for that making the brick. It may not be patternable for the same thing for the tile. Suppose the same combination you make it the brick or tile is the same.
Okay,
Okay,
sir.
that may not be patternable, but you have some idea like making the brick or making the tiles under some new name. Tiles is tiley like that.
Yes,
That
sir.
is patternable. That is patternable. And the process is maybe patternable, and upgradation of existing application also, upgradation of existing application also patternable. That is in the section 3.1.3a is given.
Okay, sir.
This you can upgrade the any process also possible to the pattern. For example, you can ask directly question the fly ash brick. You add some metal admixture. It's maybe patternable or may not be patternable. It's correct.
Yes, sir. Something like that, sir.
Yeah, yeah, like that. So that may not be exactly patternable, but you can claim I add this kind of material in that existing mix. I can enhance the strength, enhance the durability, enhance the performance. That you can claim in the section. That is the possible.
So it is patentable, sir, in that case. But that should be new finding.
Yes. Yes, new finding, new combination not allowed. For example, you can 10% fly ash, 30% cement, 40% fine aggregate. You change that 10, 30, 40 may not be claimed.
Okay.
That may not be claimed as a patent.
Yes, sir. So any upgradation or maybe application, you show it in some other
Application,
application.
industry application,
The
yes,
same,
you can.
maybe same product that is there, you show it new application. Is it patentable, sir?
Yeah, new application is patentable. For a maybe application in that your process in the civil industry, it's maybe used in the biotechnology industry.
Yes, sir.
That is okay, patentable. For example, we are involving like that. We
Yes,
are
sir.
finding some bacteria. That
Yes,
bacteria is maybe applicable for civil field as well as mineralogy field also. The chemicals. That is
yes,
a
sir.
possible. But one more things I want to add here. Suppose
Yes,
you file the patent related some microorganisms and all those
sir.
things. You get that certificate from biodiversity from Chennai. You want to get it clearance from the biodiversity. That is on another parallel process.
Okay, sir.
Before apply the patent, you maybe get that certificate. What are the microorganisms involving this? You can easily get the pattern. Otherwise, you wait some more year to get the pattern. In my case, one case is like that only. Still, I am waiting for that biodiversity clearance. So that's
Okay,
maybe
sir.
avoid in futures.
If you go parallelly, work parallelly, that can be avoided. Something like this.
Yes, I may avoid it. Yes.
Yes, sir. Sir, one more query.
Hmm.
I just we were discussing. I add some admixture fly ash and something I will add another admixture. I will improve something, and probably that may not be a very inventive step. It may be a regular mixing,
Hmm.
something like that. So, is it patentable, sir?
No,
Just
the
changing the mixture
usually we are
admixtures.
thinking like that. No, that is very difficult. But because they know the well, the patent office
Yes, sir.
controller and the public also. I have the patent means I want opposite to others now. So I
Definitely.
have some sequence steps
Yes,
to manufacturing some the break. I am the inventor of
yes.
the some patent. I have the rights to opposite your patent. No?
Yeah, definitely.
So this is this pattern is already I granted I avail this pattern. So he is replicating my step again. The small modification and changes. Don't give the pattern. I give the opposition to your
Okay.
pattern. Yeah, one opposition come means you want to rectify all. So
Okay.
our civil it's not a big deal, but you get the pattern in the pharmaceutical
Pharmacy, yes, sir.
field. Suppose they find some medicine, some tonic or some distillery
Molecular
industries
structures,
also.
yes. Yes, sir.
Yeah, that is a very competitive. Within the fraction of second, they file the pattern is the first. They only claim. So,
Yes, sir.
but civil and all, it's not much more interesting and more competition. Even the mechanical field also more competition because they found some technology for the engine manufacturing and shape and something. Who's register first? They will
Yes,
claim.
sir.
Otherwise, no.
Probably even telecom industry also, sir, because that is the most budding
Yeah.
one.
Yes. Similar.
Yes, sir. I was just interested in knowing some inventive step in a patent.
Yeah.
Uh, Inventive step in a patent.
Innovative step in the patent related to their work now.
Yes,
I
sir.
am the material man.
Yes, sir.
I'm the basically structural dynamics. So we have some property. So the field is different. No? You are the master in your field.
Yes, sir.
So what is the steps, inventive step, and also you only knows for your work. So you want to think laterally. So all people thinking about the compressive strength.
Yes, sir.
So that's may not be patternable. So you think different way. So that is one clue given to you. And all people thinking about the durability. So why not think about strength or durability like that combined one like that you want to think different. Definitely you get that pattern. That gives to that particular inventor under their domain. I cannot speak with metal aspect. I cannot speak with some structural part or cannot speak with some computer part and all those things. That is the
Okay.
problem.
Sir, can you tell with respect to one of your patents, any basaltcrete or whatever? What was the
Yeah,
inventive
I
step?
already explained. No? Yeah, inventive steps. If I can take that, we took that. I can explain in the glass crate. It's very comfortable.
Okay.
We took that glass, waste glass from in around us. That we found that the glass powder have the rich amount of alumina as well as silica. So you can look at that any porcelainic material have the rich amount of alumina and silica. It gives a binding property.
Okay, sir.
Then the alumina and silica, it's maybe unreacted form. It's not used for us. We want to react that alumina and silica like a geopolymer concrete. It's right.
Yes.
Geopolymer concrete, we want to activate the alumina and silica. Here also, using we use those two methods to activate the alumina and silica, rich amount available in the glass powder. One is a chemical, another one is a mechanical treatment.
Okay.
We went for some chemical along with that SICRI, Central Electrochemical Research Institute, Karaikudi, Tamil Nadu.
Yes.
Karaikudi, Tamil Nadu, joined with their scientists. We found some combinations of chemicals and put in that soaked some process
Okay.
for that soaking that glass powder in that solution, potassium hydroxide and sodium silicate and all. Then we want to etch that surface of glass powder particle and examine this glass particle by means of SEM, XRD, XRF and all. We treat that material up to our required consistency. After that, add the cement or another mineral admixtures or something, chemical admixtures, whatever it may be. Then how it performs in the concrete or cement mixing like that. This is one
Yes.
process.
So all this must
Another
be
process
novel
is,
purpose. Yes, sir.
yeah, that is another process is usually the people grind the glass powder, right? You can get that powder.
Yes.
Then how to activate the charges of that glass powder? So either we can give the charges mechanically or chemically. One charge is given by chemically, but the treatment. Another one is a mechanical. We can alter some grinding process
Surface
of that
properties.
surfaces. We can each like our pimples. One
Yes.
is possible to make it the projection, or otherwise we make it as a some pinch in that. So we want to optimize that pinch where it is that where it is possible. So these kind of things we did the mechanically for the grinding. We want to change this size of the ball for the grinding process. We can get that powder in that particular consistency. Again, mixing with this, we can get that. All other processes, the two process. One is a chemical, another one is a mechanical process. That is the innovative things we got the pattern.
Okay, sir. Thank you so much. Any questions from the students? Uh, if there are any no questions, sir, this is the last question from my side. So,
Yeah, you
sir,
can ask,
suppose,
no problem.
yes, sir. Suppose I have already filed a patent now, sir, and it's under examination. Now I find that there can be made some improvisation to be made to the draft I submitted, or maybe claims, whatever I'm claiming now. So, is it possible technically?
So basically, up to that provisional, you can change anything. Once you completed that complete specification,
Yes, sir.
you cannot be change that claim and all. But after getting your examination report, you can claim. You
Yes,
can
sir.
ulta like that. So
Ah,
this is now I am not talking about that claim. I am talking about this way. Like that, you can argue with that controller of examination. They convince means you can get it. But very difficult to add the claim. If you can reduce the claim, it's a possible. Reduce the claim is possible, but adding the claim is impossible, and adding subclaim also impossible. But we can argue with that existing claim. Slight modification you can change. That is a possible with some fee. You want to pay the fee. You can change a small modification, but you cannot change entire thing.
okay, sir.
They know well which idea you have behind of that.
Okay,
That's why
sir.
the people is facing a lot of struggle to getting the pattern now.
Nice, sir. Sir, Thank you very much for a wonderful session and giving lot of insights, first-hand insights, because somebody may theoretically talk to so many things about patent. Somebody who has done or dipped or swam, yeah, who has swim in this river, will be knowing exactly what are the real problems. And you have, in fact, enlightened us all these problems, and probably the opportunities lying with all of us, especially for the benefit of the students and all of us, our faculty members also. So I sincerely thank on behalf of our Department of Civil Engineering, Associate Engineering Bawalkot, and Institution Innovation Council, on behalf of Institution Innovation Council also. I would like to wholeheartedly thank you for this wonderful lecture, sir. Thank you so much, sir. Also,
Yeah, thank you, others. Others. And
sir,
special thanks
myself,
to Santosh.
Myself, Santosh talking, sir. My system's small.
Yourself, Santosh. You are
Yes.
talking with the others.
Yeah, yeah, sir.
That's right. Okay, okay.
Little bit
Proud. He is
technical
our
problem.
student. PhD
Yeah.
students. He got a doctorate from NITK. I'm proud of
Acha.
him. Proud to say he is our student. Okay, thank you, Dr. Santosh. Given opportunity to me here
Yes, sir.
to discuss regarding some pattern.
Yes, sir. I just
Okay,
want to
thank you
brief.
very much. Thank you, madam.
Yeah, just I
Yeah,
want to
yeah, fine.
brief. I would also like to thank our beloved principal, Dr. S.S. Engineering, who has been the source of strength and motivation, and for all these such kind of activities. And I also thank the head of our Institution Innovation Council, Dr. Anil Devangami, sir, for all the support rendered to me in conducting this program. And I also thank our beloved head of the department, Dr. PG Rakreddy, sir, for all the support extended to me in conducting uh, event. I also thank faculty members, deans, head of the departments of other college departments for all the support and attending this seminar. And I also thank Dr. Adarsh Chatra for welcoming and introducing the guest. And last and final, the student community who have been benefited by this wonderful talk. Please don't miss such talks, because to get a person of such a caliber and profile is very difficult to get. And first hand person, whenever such we get such opportunities, please make a best use of such things, such attacks. Thank you very much, everyone, for all the support rendered to us. Also, finally, I would like to also thank the coordinator of our Association of Civil Engineer, the Professor S.A. Kambli, sir, for supporting this event through Association of Civil Engineers, Department of Civil Engineering. So, thank you, everyone. And finally, I thank Dr. Palani sir. Good night, sir, everyone. Thank you, everyone, and good night, sir.
Thank you very much, Jai Hind.
Thank you, sir.